From the PEP Radio Newsroom, this is the latest news blast for this hour. LGBTQ Nation is reporting that hate monger and former county clerk Kim Davis has asked a second time for the Supreme Court to take her case with anti-LGBTQ plus advocates, hoping it could be the one to lead to the justices overturning marriage equality. Davis, a conservative Christian who has been married 4 times, the irony of that, refused to provide marriage licenses to gay couples in 2015 after the U.S. Supreme Court legalized marriage equality. Davis told the couple, who ultimately sued her, that she was acting under God's authority when she refused to issue the license because she believes marriage is only between a man and a woman, or a woman and 4 other men at various points within her lifetime, as long as she deems it necessary. Is that how that works? She was jailed for 5 days for contempt for refusing to comply with a court order and has spent the last decade entangled in legal battles with 2 of the couples she discriminated against. We are asking the court to recognize the First Amendment as an absolute defense for Kim Davis and to overturn the 2015 Obergefell opinion, which has no basis in the Constitution. Tell that to Justice Anthony Kennedy. Davis's lawyer, Matt Staver, a bigot, of the anti-LGBTQ plus Liberty Council, even bigger group of bigots, a Southern Poverty Law Center designated hate group, told the Lexington Herald Leader. Staver also claimed Obergefell did significant damage to the historic definition of marriage. Which one was that, actually, where kids get to marry one another when they're 14 years old, like happened in Tennessee, Arkansas, Alabama, Georgia? Is that the definition we're talking about? Or are we talking about a different one that excluded various groups of people, such as black people marrying white people, as is the case with Justice Ruckus himself, who is currently serving on the U.S. Supreme Court? Anyway, Staver also claimed Obergefell did significant damage to the historic definition of marriage, to states' rights to religious freedom, and to the rule of law. It is time to end this legal fiction and undo the damage soon, he said. According to the Herald Leader, the court request filed by the Liberty Council bigots on Thursday asked the court to answer 3 questions: whether marriage equality should be overturned, it shouldn't; whether Davis has qualified immunity, she doesn't, that bars her from paying damages to a couple who sued her, maybe she could be sued completely into the ground; and whether requiring her to issue marriage licenses to LGBTQ plus couples was a violation of her religious freedom. No one cares. Qualified immunity protects government officials from personal liability for violating someone's rights unless they are in violation of clearly established constitutional rights, as the Supreme Court case of Harlow v. Fitzgerald decided in 1982, as if the current Supreme Court cares about any sort of clearly established constitutional rights, or for that matter, stare decisis. They just don't care. Davis has already been denied qualified immunity multiple times in this case. In the most recent request to the Supreme Court, Staver, other Liberty Council lawyers echoed the thoughts of Supreme Court Justice Uncle Ruckus, Clarence Thomas, and argued the decision in Dobbs v. Jackson Women's Health Center that overturned the federal right to end a pregnancy should serve as a precedent in this case, and we all have seen where that has turned out. Thomas opened the door to marriage equality being overturned in 2022 when the Supreme Court overturned reproductive rights. In his concurring opinion, he wrote that same logic that was used to overturn reproductive rights may be used to overturn marriage equality and access to birth control. I am not making this next part up. The case in question involves David Ermold and David Moore. Not me. I swear it's not me. But if it is, I want my monies. Okay, I'm just saying I want my monies. Last year, Davis was ordered to pay $260,104 in fees and expenses to the couple's attorneys. And in 2023, she was ordered to pay them $100,000 in debt. Yeah, I want my $100,000. That was me. Okay, just clarifying, I want my $100,000, bitch. In damages for violating their constitutional rights. This is the second time Davis has requested the Supreme Court hear the case. The first time was in 2020 and the court declined. Oh, go figure. Although some on the right believe Davis is the key to ending marriage equality, experts told the Herald Leader that the court is unlikely to use this case to do so, since Davis's actions were blatantly unconstitutional and since the case is so old. Ermold and Moore's lawyer, again, not me, Really, I wish it were, but it's not. Bill Powell agreed that not a single judge on the U.S. Court of Appeals showed any interest in Davis's rehearing petition, and we are confident the Supreme Court will likewise agree that Davis's arguments do not merit further attention. That's the news blast for this hour. If you are watching our videos on YouTube, I hope you had a laugh. Please subscribe to our channel. Download the Live 365 app to take PEP Radio with you wherever you go. Up next is the Meadville area weather forecast right here on PEP Radio.